So now you're with us, I'm going to put some questions to you. Sorry that we're kind of setting off at a pace here, but what we wanted to start with is, restructure the beginning. What do we mean by a restructure? Can you give us some examples, please?
Yeah. Oh, okay. Thanks, Anna. So if we look at a dictionary definition of what a restructure is, the Cambridge Dictionary sets it out as to organise a company, business or system in a new way to make it operate more effectively. That's the definition, and I don't think it's a particularly nice definition within the Cambridge Dictionary, given it says to make it operate more effectively, because we know in reality what ultimately a restructure is about is cutting costs. And again, we all know that that tends to have a negative impact on employees. Quite simply, it's not good news. Examples of a restructure include where an employer proposes to change terms and conditions of employment, such as changes to a pay structure, changes to contractual shift patterns. So if there's a particular shift system in place that's contractual and the employer is looking to change that, then that can fall within the definition of what a restructure is. Changes to where the work is actually carried out, so maybe a change in location, and also a restructure can apply to changes in the job role itself.
Thank you for that as a brilliant introduction of what we're talking about. So as I said before you joined us, you're from Thompsons, which is a really crucial law firm that does a lot of work with trade unions. So what we're interested in is employment rights. What employment rights do people have in a restructure situation?
Okay, so a restructure situation is quite broad in terms of employment rights or employment law. The obvious one that stands out is redundancy, and when we're talking about rights, the right to a redundancy payment and the right not to be unfairly dismissed. That's something we'll go into later on. The rights under a contract. So when we're talking about a restructure in the context of changes to terms and conditions, what are the members' rights under the contract? We need to consider that. A restructure scenario may be involved in a TUPE situation, so where there's a transfer of business or a service provision change. And also, in terms of employment rights, a restructure gives rise to questions as to whether or not the changes are potentially discriminatory. So is there possible age discrimination? Is there indirect discrimination, such as sex discrimination, indirect sex discrimination, where, for example, an employer is looking as part of the restructure to change flexible working arrangements? Again, that could apply to people who are associated to somebody of a certain protected characteristic. So within that scenario, you're talking about maybe carers of a disabled dependent. It also gives rise as well to questions in relation to automatic unfair dismissal as well. So if, for example, a restructure puts a woman on maternity leave in a redundancy situation and work isn't found for her, that may give rise to a claim for automatic unfair dismissal. Like I say, Anna, it is quite a broad area. What I'm looking to do today is to give an overview within this conversation of the legal rights or the legal position within a restructure scenario. But that's just a few examples. They're just a few examples of what rights may apply in a restructure scenario.
Thanks, Keith. And we're getting our audience to share with us some of their experiences of this. And I think almost all the examples you've already mentioned. someone has dealt with. So that's great. That well, it's not great that they're dealing with them, but it's good to hear that we're providing some good practical examples. So let's start with probably the one people might be most familiar with, redundancy itself. What does the law say on redundancy? And is this something we should always consider within a restructure?
Yes. So taking the second question first, is redundancy always a consideration? Well, yes, it is, because what we're looking at here is the termination of the contract of employment, and the question therefore is, what is the reason or the potentially fair reason for dismissal? And redundancy is one of the potentially fair reasons for dismissal that may apply in a restructure scenario. We'll look at the other, which is some other substantial reason later on. So within a redundancy situation, the classic scenario outside of a restructure process is, of course, the closure of a business. But within a restructure, redundancy may apply because of the definition of redundancy under Section 139 B of the Employment Rights Act 1996. And what that says is that an employee who is dismissed shall be taken to be dismissed by reason of redundancy if dismissal is attributable wholly or mainly to the fact that the requirements of the business for employees to carry out work of a particular kind, or for employees to carry out work of a particular kind in the place where they were so employed, have ceased or diminished or expected to cease or diminish. So what's key here in the restructure scenario is whether the work that's being carried out by the employee has ceased or diminished or is expected to cease or diminish. So it's the requirement for employees to do work of a particular kind, which is significant in a redundancy scenario. So that then begs the question, what is likely to amount to a redundancy situation within a restructure? So if as a result of a restructure there's fewer employees who are needed to do that particular kind of work, that could amount to a redundancy situation. Or if the restructure leads to a reduction in the amount of work, but there are still the same number of employees doing a job, so where there's a change in job function, that could give rise to a redundancy situation. So just to give some examples of that, so an employer may carry out a restructure process where there's new technologies that come into play, so if that change in technology produces, for example, the same level of output, if that can be achieved, then that may lead to a reduction in employees. Or a redundancy situation may apply where the employer decides to remove a layer in an organization's hierarchy and then redistributes the work or the job function to other employees. That's an example of redundancy within a restructure scenario. You've also got a reallocation of duties. So again, the classic example where you've got two jobs merged into one. And the dismissal of an employee for refusing to carry out reduced hours may also amount to a redundancy, although as you'll see later, that could fall within the SOSL, the some other substantial reason scenario. The best way to work out if there's been a reduction in work of a particular kind is to consider what the employee or the member was doing before the reorganisation and what's expected afterwards, so following the reorganisation. Will the job be the same is the question to ask yourselves. So will it require the same skills, experience, responsibilities, pay, and other terms and conditions? But just to note on changes to terms and conditions, a simple change in terms and conditions does not in itself amount to a redundancy situation. So probably a bit of a long answer, Anna, but I hope that answers the question.
I think that was really helpful, Keith. Thank you. And I particularly like the test that you've suggested for if it's a redundancy, look at what they were doing before and then look at what the situation is after the fact. We are getting some questions posted from the audience that apply to this, but I'm actually going to come to those afterwards because I think we've got a lot more to get through first. So the situations you've just described, what obligations are there on the employer in this situation? And just before you start answering that, could you, any way you could sit a little bit closer to the microphones? A couple of people have said that it's a bit quiet, so hopefully that will help.
Okay. I'm just wondering if that's better. Sorry, the screen's getting closer and closer. So
I think a little bit. Don't worry, my head is big as well.
I know.
So let's see how we go with this on this next question, and then we can see if we need to adjust the sound again. So what obligations on the employer are there in the situation you just talked about?
Okay, the obligations on the employer are twofold essentially. So I think firstly, if we look at the obligations on the employer as it applies to individuals, because of course, and as many people who are in this webinar will be aware, that there's also obligations collectively that apply, which we'll come on to in a second. But as far as the obligations on the employer to the individual employee are concerned, the employer has to warn and consult employees about redundancy. So that applies both individually and collectively, which is what I'm hinting at. The employer has to apply a fair redundancy selection procedure. So it needs to identify the appropriate selection pool and apply a fair selection process. It's also got to consider suitable alternative employment. Now, when it comes to applying a fair selection procedure, the employer is expected to give consideration in relation to identifying the appropriate selection pool. So, for example, that's by including those who carry out the same or similar job roles within a selection pool. And then in terms of selecting those within that pool for redundancy, then again, as I think most people will be aware within this call, that the employer is required to follow a fair selection process. So again, that's the use of objective and non-discriminatory selection criteria. If the employer falls foul of those requirements, so if it fails to warn and consult employees, if it fails to follow a fair selection procedure, if it doesn't consider suitable alternative employment, then employees who have 2 years service or more, that could give rise to a claim for unfair dismissal. So that addresses the point in relation to individual consultation. Anna, unless you've got any further questions in relation to that before we move on to collective consultation.
No, that's a nice segue in actually to our next question that I've got for you. Is we hear a lot about consultation. So what do we mean in a collective consultation? What does that mean? Okay. So there's a recent decision from 2023 in the Employment Appeal Tribunal. It's Haycox, the ADP RPO UK Limited. And the Employment Appeal Tribunal, they confirmed the importance of collective workforce consultation. And that's even if, this is quite useful to know, even if the union isn't recognised in irrespective of the number of dismissals in the workplace. So that may be taken into account by the tribunal when considering potential unfair dismissal claims. Now, when we talk about collective consultation, that's within the Trade Union and Labour Relations Consolidation Act 1992, Section 188. And again, I would have thought that many of you on this call are
familiar with Section 188, but just by way of reminder, or for those who are not aware, what Section 188 says is where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, then the employer shall, so it's got to consult employee representatives about the dismissals in good time, and in any event where you've got 100 or more proposed redundancies within the establishment within that 90-day period, that consultation has to take place at least 45 days before the first of the dismissals takes effect. Where there's less or fewer than 100, that has to take place at least 30 days before the first of the mass dismissals takes effect.
Just a quick question there, Keith. Is that 30 and 45 working days, or does it include weekends, bank holidays as well?
Yes, it's 45 days, 30 days. It does include. It's based on the calendar week, so it does include weekends and bank holidays.
I think a great interesting point to note there, if it's Christmas or if it's Easter where we get extra bank holidays, of course, bear that in mind. You don't get a reduction.
Yes.
Okay, so this process, consultation, 40 days, 45 days or 30 days ahead of any proposed redundancies, what things should a rep do to prepare for this? Is there any background work they could be doing?
Yeah, the sooner you can get hold of the business case, the better. And if you can get hold of that, is to scrutinise it, to try and identify what the employer is or may be proposing. And in particular, within a collective consultation scenario, whether the employer is proposing to dismiss, 20 employees or more. I think it's useful to try and identify at an early stage as well, in relation to any proposals, whether or not in terms of a change, a proposed change in job function, whether jobs have simply got different job titles, but actually the role remains the same. If that's the case, then that's less likely to give rise to a redundancy scenario. Having said that, that could be a means on the employer's part to try and reduce pay or reduce other rights, for example, holiday entitlements or the way holidays are, holiday pay is calculated. Try and identify as early as possible whether or not there's fewer employees required to do the same work, because that will give rise to a redundancy situation. And if the employer is proposing to dismiss 20 or more employees within a 90-day period, that triggers the employer's requirement to follow Section 188. It's also useful to try and pinpoint whether or not the employer has consulted with the workforce whilst proposals are at a formative stage, because if not, that might amount to a breach of Section 188. Again, we'll come on to that in a second, because if the employer's decision is fixed, that may give rise to an argument that consultation is not meaningful. And also, it's important to identify at an early stage when the proposed redundancies are likely to take place.
That's great, as information for reps of what they can do to prepare, because then they're able to answer questions quickly, both of members and with the employer, I think. So my next question is about if the restructure includes changes to terms and conditions. This is of the people staying, not necessarily people being made redundant. What does that mean for reps and members? Changes in terms and conditions?
Okay, it could mean a number of things. First and foremost, an employment contract is a legally binding contract, and in order to change it, it requires the parties to that contract to agree. So what an employer can't what an employer can't do, I mean, if it does, it will give rise to breach of contract claims, but what it can't do is unilaterally impose changes to terms and conditions, because, like I said, that will be in breach of contract. So what's expected of an employer in that situation? Well, firstly, and you've probably seen this, the employer shall first try and seek agreement of the affected employees. The reality, however, is this, though: if the changes are detrimental to employees, then quite simply, you as their representatives in the workplace, myself maybe as the lawyer, we won't be recommending that they accept those changes. The law, unfortunately, is an ass, though, because as you've probably seen, it's been reported in the news, and what happened with P&O is a classic example of this. If employees do not accept changes to terms and conditions, basically gives the employer the following options. So what the employer may try to do before it takes the nuclear option, which I'll come on to in a second, which is what happened with P&O, the employer may seek to divide and rule, so basically bypass the union and go direct to individual employees and ask them to agree. Where individual employees do not agree, then the nuclear option is to basically serve notice on those employees that they're going to dismiss them and re-engage them on new terms and conditions. And that gives rise to further issues, which we've already spoken about, and I'll just delve more into the requirement to collectively consult where the union is recognised. So firstly, the definition of redundancy under section 195 of TUPE applies where the employer is looking to dismiss and re-engage employees on lesser terms, and the duty to consult under TUPE under section 188 of course applies where the employer is proposing to dismiss and re-engage 20 or more employees at one establishment within a period of 90 days. That consultation must be meaningful. So consultation, the legislation requires consultation to be meaningful, and that requires the employer to, and the employer shall consult on ways of avoiding the dismissals, reducing the number of employees to be dismissed, and mitigating the consequences of the dismissals. And what's required of the employer is it should provide adequate information and the reasons for their proposals to employee representatives on a scenario where the union's recognised to the union reps. For consultation to be meaningful, it must begin when the proposals are still at a formative stage. Adequate information must be provided upon which to respond. Adequate time in order to respond to the proposals must be given, and the employer is required to give conscientious consideration of the response to the consultation. If the employer fails to engage in meaningful consultation, then that could give rise to a claim under section 189, which is that the employers failed to consult as required under Section 188. The other situation you've got where the employer is looking to drive through changes to terms and conditions, and I mentioned it when we were talking about redundancy. A tribunal, when assessing an unfair dismissal claim, will consider what the reason for dismissal was, and it can fall within, in a restructure, it could potentially be redundancy or some other substantial reason. Some other substantial reason, or SOSR, is a catch-all reason for dismissal, and it does cover the restructure scenario. So what does the employer have to do? What's expected of it in an SOSR dismissal situation? Then the employer has to demonstrate that the changes have discernible advantages to the business, and it's not just enough to assume that they will. So there has to be some evidence that change is required, albeit the tribunal will not overly scrutinise the employer's proposal. The employer has to show that it's taken employees' interests into account. They can't simply be ignored. So there's a balancing exercise between the needs of the employer and the employee. The employer is expected to do all they reasonably can to explore alternatives for a limited temporary period if current market conditions could change. And the employer is also expected to act in accordance with equity. So, for example, there's one case, Garside and Laycock Limited versus Booth from 2011. This was a case concerning employees who were dismissed when they refused to take a pay cut. The tribunal said in that case that equity could involve consideration as to whether management were also subject to the pay cut, as well as the general workforce. So all those factors need to be taken into account. I have to point out, though, it's not a huge hurdle for an employer to overcome to establish SOSR both as the reason for dismissal and also demonstrating that the dismissal process was fair, which are essentially the requirements that make up an unfair dismissal claim. The tribunal will consider whether or not the employers acted reasonably and whether dismissal was in the band of reasonable responses. And if the employer takes those factors into account, if the employer can demonstrate to a tribunal that it's taken those factors into account, then dismissals are likely to be fair. And it is quite difficult for an individual, I think, as some of you will probably know on the call, to succeed in unfair dismissal claims where the reason for dismissal is some other substantial reason. Sorry, I'm going on a bit, Anna, but can I just quickly refer everybody to the draft code of practice on dismissal and re-engagement?
Absolutely, anything that's helpful.
Yeah. Okay. So the draft code of practice sets out what's expected on the part of the employer where it's proposing to dismiss and re-engage employees. So I'm using the word draft because it hasn't taken effect yet, and I'll come on to that in a second. What the draft code sets out is that as representatives, we can request from the employer what the proposed changes are, including what the proposed new and or revised changes will look like, who will be affected by those changes, the business reasons for the proposed changes, the anticipated timings for the introduction of them, and the reasons for them, any other options that have been considered by the employer, and also the proposed next steps. Now, there's no expectation on the employer to agree with employee representatives, with the recognised union, for example, what these measures are. The expectation is that the relevant information is provided, that other alternatives have been explored before, like I say, the nuclear option of dismissal and re-engagement takes effect. Where though agreement can't be reached, then as representatives, we can do this now, but when the draft code takes effect, we can request that the employer re-examines its business strategy and its plans, taking into account the damage that could be done to the workforce. Now, when does the draft code come in? The government published its response to it on the 21st of February, so it's very, very recent, and it requires approval from Parliament, and that's due to come in. That's due to take place in the summer. So this draft code of practice is due to come into force at some point in the summer. We haven't been given an indication in relation to the date.
Thanks, Kate. I posted a link to the draft in the chat so people can look at it in their own time as well, just for the audience. So that's really helpful. Thank you.
Okay. Can I just point out very quickly, Anna? Sorry.
Yeah, of course.
That, what the code doesn't do is ban the act of dismissal and re-engagement, hire and refire. Fire and rehire altogether. The Labour Party said if it's elected in a general election, that it does wish to ban it. Whether or not that happens if Labour are elected, that remains to be seen. Just to point out as well, in terms of the potential consequences in relation to employment tribunal claims, a breach of the code itself will not give rise to a claim. But when the tribunal assesses whether or not the employer has applied a fair dismissal process, it will be taken into account. The code as well only applies to SOSR dismissals. It doesn't apply in a redundancy situation. And it applies irrespective of the number of dismissals as well. So if there's less than 20, the tribunal can still take into account the code. Sorry, Anna. I've
no need to apologise at all. It's all really helpful information that I think our audience are really taking things away from this for than their role as a rep. Okay, we're going to move on to a slightly different area now. What is TUPE and when does TUPE apply? Okay,
so what is TUPE? So TUPE comes into play when there is a transfer of business, for example, from one company to another, or a service provision change, so where there's outsourcing or insourcing. Now, in terms of business transfers, TUPE does apply where there's a change of business of one group company. So when you've got a group of companies, when there's a business transfer within that group, TUPE will apply. So it's known as intra-group business transfer. So it will apply in that situation, as well as, for example, if Barclays were to take over the Nationwide, it would apply in that situation as well. A service provision change, service provision is normally where a company carries out a particular contract. So the classic scenarios are where you've got cleaning or catering services, and that works outsourced, say, by a local authority, an airport, an NHS trust to another company. That's a service provision change. If there's a change from one service provider to another, then TUPE will apply. In terms of the rights under TUPE, there's a right to be informed about a relevant transfer, and that right, unlike under section 188, which we've seen, There isn't a set time scale. It just says long enough before the transfer. There's a requirement to notify employees of the fact of the transfer, the date it's due to take place, the reasons for it, and the likely legal, social, and economic consequences for the affected employees. The right to consult, just to point out, the right to consult only applies if the employer envisages that it will take measures in connection with the transfer. The employer is the transferor, or the company or organisation where the business or the service provision is being transferred from. So actually, the company or organisation where members are being transferred into, there's the right to consult doesn't apply to them. So that gives an overview, Anna, of TUPE. And I think
that's great there, and the rights that members have under that, which I appreciate this is quite complicated, but we've covered the broad angles. But I want to ask you now a bit about equalities, because you touched on it earlier. What are the equalities angles that reps should keep their eyes open for, just to be aware of, so that they can act on them if necessary?
Okay. So in terms of equalities, I mean, there's the issue of discrimination is very live within a restructure scenario. So the issue, for example, of age discrimination comes into play possibly if the employer rushes through the reorganisation in the hope of making an employee redundant, and that means that the employee concerned doesn't qualify for an enhanced pension. I've mentioned earlier that it can apply within the scenario of automatic unfair dismissal. So, for example, where the employer fails to offer a woman who's on maternity leave suitable alternative employment, if there is one. Just jumping back to TUPE, there may be a claim for automatic unfair dismissal if the sole or principal reason for dismissal is the transfer itself. In terms of other aspects of discrimination we need to be alive to, there's indirect discrimination. So if, for example, the changes of a shift pattern disproportionately affect working mothers, that may give rise to a claim for indirect discrimination. There may be a claim for indirect associative discrimination if, for example, somebody, an affected employee, is the carer of a disabled person. That may give rise to a claim there. There may be potential claims for disability discrimination. So, for example, failure to make reasonable adjustments or discrimination arising from disability. If the employer doesn't consider reasonable adjustments moving forward, or if the employer doesn't consider viable alternatives to dismissal. There's various. It's very, very fact dependent, because of course each scenario is different, but it's something that we need to be alive to. Possible discrimination within a restructure scenario, because if it disadvantages a particular group of people who have a protected characteristic, then that could give rise to possible claims under the Equality Act.
Thanks, Keith. So I think reps, what is important there is just be aware of what it could affect. It might not necessarily be announced. In fact, it won't be announced this is going to affect a particular group, but just keep in mind what is being said and what the effects of that could be. Just think a little bit creatively. Okay, I'm actually going to take a couple of questions from the audience that we've had posted before I come back to you, Keith, to ask about what your top tips are for reps. So we have had a lot of questions. I'm going to try, we're not going to be able to answer all of them, I'm afraid, because but I'm going to try and group them together so that we can cover as many themes as we can while we've got Keith here. So quite a few people have asked about if an employer is presenting a restructure or a redundancy situation, are there any rules around the evidence that they have to present, or is it up to them?
It depends on what situation we're looking at. I mean, at the outset, the employer needs to set out, needs to explain what its proposal is. So what are the proposed changes, who'll be affected by them, and the business reasons for the proposed changes. Now, I've jumped back there to the draft code of practice on dismissal and re-engagement, but these are very much factors that a tribunal will take into account. Now, there has to be some evidence presented by the employer that the changes are necessary. Now, as I said before, the employer will not overly scrutinise the available evidence, but the employer does need to demonstrate that there is a business need for those changes. So what I recommend that people do within that scenario is, and a link was posted to the draft code, take a look at that, identify what it says in relation to the requirements or the obligations on the employer. And if you feel that the employer is not providing the necessary information that's needed in order for you to be able to represent members and also participate in the consultation process, to point out to the employer that it's expected that they provide this information.
Thanks, Keith. And you mentioned just there about a tribunal. We've had lots of questions about what a rep should do if they feel their employer or the organisation is not doing what they should. What is the process for them then going to the employer, and what can they expect in the way of remedy?
Okay, so the option is always there to raise a grievance. Grievances can be raised at the outset, whether that's done individually or collectively. What I recommend reps to do, workplace reps to do in the first instance, is to discuss the matter with the branch or the region with a view to obtaining legal advice in relation to what steps can be undertaken to try and at least elicit some form of positive outcome. I may come on to this in a second, but if everybody on this call could be cognizant of the time limits that apply, because of course the vast majority, in fact, with the exception of redundancy pay, which is a 6-month time limit, all the claims I've discussed today, there's a 3-month time limit. So the quicker advice is obtained through the appropriate chain within the union, the appropriate structure within the union, the better in terms of agreeing a tactical approach, being able to represent members individually, and addressing how you're going to raise individual issues that relate to individuals and issues that relate to your members as a collective.
Thanks, Keith. And I think the key point there is, remember, always there's always an option of getting advice from your union. Many unions have links with law firms like Thompsons, where you can have access to another level of advice from people like Keith or or his colleagues. So never forget, you can always approach your union. We talked quite a lot about changes in terms and conditions as a result of a restructure or after a redundancy process. If people secure a new role with different terms and conditions as a result of this, what should happen then? Should they get a new contract with the employer, or should they get some sort of notification of the change?
Yeah, it could potentially take it could take either form. It needs to be documented that the contract has changed, either through a brand new contract of employment, or if it's just simply a change in job role, it might just require the employer issuing the employee concerned a letter or a memo which they're required to sign, which both parties are required to sign, just to confirm what the changes to the contract are. And it might say that your changing job role is changed from X to Y with effect from the particular date. All of the terms and conditions remain the same. So it could take either form.
And can an employer change any term and condition they want? If they got free rein there?
No. Any changes to the contract, because they have contractual effect, because they are legally binding, that must be agreed between the employer and the employee. That's
really helpful, thank you. Right, I'm just trying to find another question that was really that we'd had a lot of people posting about. One second. We need to talk a little bit more, I think, about the dates element here, because I know that we can be the time limits are quite important. Before we talk about remedying dates, what guidance have you got around the collective consultation period? Are there timings for that? Should there be a set start date and end date, or is it open-ended?
Well, as I was saying earlier, the collective consultation should begin when the proposals are at a formative stage, not when the employer has made the actual decision surrounding the proposals, because if it does that, then it will give rise to an employment tribunal claim. But bear in mind the timings, that where the proposal is to dismiss 100 or more employees, the requirement is to begin the consultation at least 45 days before the first of the dismissals are due to take effect. And where there are less than 100 proposed dismissals, it's 30 days before the first of the dismissals are to take effect. But as I say, in terms of timings, the requirement on the employer is to begin the process as early as possible in order to enable meaningful consultation to take place.
So what I think is the $1 million question here is meaningful. We use that word a lot.
Yeah.
Is it going to be a case-by-case basis, or
yes.
Are there any generalities we can apply here?
Yeah. It's going to be, because in terms of what the Act defines as meaningful consultation, it's about ways of avoiding the dismissals, reducing the number of employees to be dismissed, and mitigating the consequences of dismissals, for example, by offering suitable alternative employment within the organisation, or providing the affected employees with assistance to look for alternative employment elsewhere. So they're the parameters set within the Act. In terms of whether or not a particular employer has consulted meaningfully with employee representatives within a particular scenario, that's going to be highly fact sensitive, and that's something really that can only be answered when you're presented with the full facts. But like I say, the Act does set out what the general parameters are in terms of what meaningful consultation is, and it's about avoiding the dismissals, reducing the numbers be dismissed, and looking at alternatives to dismissals.
Thanks, Keith. We've talked a bit as well about new roles or alternative roles in a restructure. What guidance is there if someone is offered a new role and they don't want it, if they think it's not suitable? Is there a test that we can apply there?
That goes slightly beyond the scope of today, but within a redundancy situation, then the statutory common law trial periods would come into play. So that basically grants the employee time to consider, whilst working in the alternative role, whether or not that position is actually suitable. The law itself specifies that the role needs to be suitable, so the employee is able to do it, is capable of doing the job, maybe I should say, but also reasonable as well. So, for example, if it requires more travel time, and that impacts childcare arrangements, or in terms of if somebody is dependent on public transport, and a change in location requires a 2-hour trip at the beginning of the day, then the role offered may not be suitable. Again, it's very much fact dependent on the role, but there are trial periods in place, and the law does protect individuals if the role offered is not suitable or a reasonable one.
Thanks, Keith. So I've got one more question for you, but which will sum up really. So what are your top 3 tips for workplace reps if they are facing a restructure, and their members are coming to them with questions, and they've also got to deal with management? What are your top 3 tips?
Okay. First of all, I think as workplace reps, liaise with the union, whether it's the branch or the region or elsewhere within the union. That's number one. Secondly, I think the biggest takeaway for today is to be aware, be alive of the potential issues that are in play, and the various potential claims that may arise out of a restructure scenario. But it's also to be important. It's also crucial that you're alive to the time limits that apply, and there are various time limits in play in relation to bringing potential employment tribunal claims. So where the employee is dismissed, the time limit for bringing a claim is 3 months less 1 day from the date of dismissal. Where there's been a failure to consult under section 188, then the time limit for bringing a claim, and it may be the union's claim if the union was recognised, the time limit for bringing a claim is 3 months less 1 day from the last of the mass dismissals. So there may be a whole series of dates when dismissals take effect. It's the last of the mass dismissals within the 90-day period. That's when time starts to run. A claim for breach of contract can only be brought once the employment in the employment tribunal, once the employment has come to an end, and the time limit for bringing that claim is 3 months less 1 day from the date of dismissal. Alternatively, a breach of contract claim can be brought in the county court, where you've got the longer 6-year time limit that applies there. Also, just to flag as well, in relation to breach of contract claims in the employment tribunal, you've got this odd situation where the tribunal can only award a maximum of £25,000. So if the claim's worth more than that, better to bring it in the county court. Finally, a claim for discrimination must be brought within 3 months less 1 day of the act complained of. So the discriminatory act, or 3 months less 1 day of a failure to act. Please bear in mind as well that in terms of bringing a claim, you can't just go ahead and lodge an ET1 in the employment tribunal now within 3 months less 1 day of when the time limit runs from. Early conciliation applies, so individuals have to notify ACAS within those time limit or within those limitation periods. Individuals have to notify ACAS that they are intending to bring an employment tribunal claim and go through that process and obtain a certificate from ACAS before they can actually lodge the claim in the tribunal. Sorry, Anna, just very quickly, just in terms of keeping an eye on the employer, keep an eye out on the business press for any early warning signs of likely reorganisations. Reorganisations, maybe because of the consultation requirements, the proposals may change and evolve over time. And in the absence of any agreements, then the consultation may be ongoing. And if consultation is ongoing, then the employer should not be issuing notices of dismissal until consultation is completed. And if it does that, it may give rise to a claim. And just be alive to as well, this is a matter for discussion within individual unions, really, but it might be prudent to negotiate a limited temporary alternative to changes to terms and conditions in circumstances where there's a real risk the employer may become insolvent, because of course the aim is obviously to avoid that and to keep as many members in employment as possible. So they're the key tips, really, to be alive to the issues, to be aware of that there's various time limits in play, and to keep a close eye on what's going on with the employer, how it's conducting itself in the consultation, and whether or not there's a possible risk of insolvency, which may be a worse outcome to individuals if changes to terms and conditions can't be agreed.
Thank you so much for that, Keith. That was really helpful, I think, as the takeaways. We've been live for over an hour now, which we've definitely gone over. Thank you so much for remaining calm under what I think was maybe a stressful first few minutes. You've been amazing. Thank you to our viewers for staying patient with us and staying actually online so that you could hear this amazing and really helpful information from Keith. A few of you have been mentioning like a kind of information cheat sheet with the top tips on. I will take this in hand and we will look into it. It might not be something we send out with the recording later today, but if it's something we develop, I'll make sure it gets sent to all of you who've registered for today. So please leave that one with me. Please do keep your eye on our website, to our alerts. We will be doing another webinar very soon. Thank you again for joining us, and thank you, Keith, for such a lot of great information, and that's really useful. Bye-bye for now, everyone.
Thanks, Anna. Bye, everybody.